Imagine you walk into a car dealership in Addis Ababa. The seller says, "I will sell you this Toyota for 800,000 birr. You have 7 days to decide. 3 days later, you return with the money, only to be told the price has gone up." Can the seller do that? Ethiopian contract law gives you a clear answer, and it is found in Article 1690 of the Civil Code. Let us begin with the exact words of the law. Article 1690 of the Ethiopian Civil Code, titled Offer with Time Limit for Acceptance, states, Subarticle 1. Whosoever offers to another to enter into a contract and fixes a time limit for acceptance shall be bound by his offer until the time limit fixed expires. Subarticle 2. He shall not be bound where his offer is rejected before the expiry of the time limit fixed. These two short subarticles carry significant weight in the law of contracts, so let us break them down carefully. The first key element is the existence of an offer. Under Ethiopian contract law, an offer is a declaration of intention by one person, called the Offeror, proposing to another person, called the Offeree, to enter into a contract on specific terms. The offer must be sufficiently clear and complete so that a simple yes from the offeree would form a contract. The second element is the fixing of a time limit. Article 1690 specifically applies when the offeror sets a deadline for acceptance. This time limit can be expressed in any reasonable form. For example, you have until Friday, within 10 days, or by the end of this month. The moment the offeror specifies a deadline, Article 1690 becomes the governing rule, not Article 1691, which deals with offers without time limits. The third element is the binding effect. Subarticle 1 tells us that the offeror shall be bound by his offer until the time limit fixed expires. This is crucial. Being bound means the offeror cannot simply change his mind, raise the price, sell to someone else, or withdraw the offer during the time limit. The offer creates a kind of legal commitment. If the offeree accepts within the deadline, a contract is formed and the offeror must perform. The fourth element appears in Subarticle 2. The offeror is released from this binding effect if the offeree rejects the offer before the deadline expires. Rejection ends the offer immediately. Once the offeree says no, the offeror is free to do whatever he wishes, even if the time limit has not yet expired. The offeree cannot later change his mind and try to accept because the offer no longer exists. It is also important to understand when acceptance is effective. According to the interpretation by Ethiopian contract scholars, acceptance begins to produce effect from the moment the offeree sends it to the offeror, provided it reaches the offeror within the time specified in Article 1690, Subarticle 1. This is connected to Article 1692, which says a contract between absent parties is deemed made at the place and time the acceptance was sent. However, the acceptance must actually reach the offeror within the time limit. If it does not arrive in time, the offeror can presume the offer was rejected. There is one more important point. Under Article 1693, even an acceptance can be withdrawn if the withdrawal reaches the offeror before or at the same time as the acceptance itself. So the contract is not absolutely sealed. The second the offeree drops the letter in the mailbox, the offeree retains a narrow window to pull back. Now let us apply this to a concrete example. Suppose Abebe sends a letter to Tufa on January 1st, saying, "I offer to sell you my Toyota Land Cruiser 99 model for 300,000 birr. You have until January 15th to accept." This is a classic Article 1690 offer with a time limit. Scenario 1. On January 5th, Abebe receives a better offer from someone else and tries to sell the car to that third party. Under Article 1690, Subarticle 1, Abebe is bound by his offer until January 15th. He cannot lawfully withdraw the offer or sell to anyone else during this period. If Tufa accepts before January 15th, a valid contract is formed with Tufa. Scenario 2. On January 7th, Tufa writes back saying, "Thank you, but I do not need a car right now." This is a rejection. Under Subarticle 2, Abebe is no longer bound. he can immediately sell the car to anyone else. Even if Tufa changes his mind on January 10th and tries to accept, no contract can be formed because the original offer was extinguished by the rejection. Scenario 3. Tufa sends his acceptance by post on January 14th, but it does not reach Abebe until January 20th. Because the acceptance did not reach Abebe within the time limit, Abebe can presume that the offer was rejected, and no contract is formed unless Abebe chooses to treat the late acceptance as valid. Now here is your exam tip. For Article 1690, remember 3 things very clearly. First, the offeror is bound only when a time limit is fixed. If no time limit is fixed, you must shift to Article 1691, which uses a reasonable time standard. Second, the offer must be accepted, and the acceptance must reach the offeror within the time limit, not merely be sent within the time limit, unless the issue is the moment of contract formation under Article 1692. Distinguish carefully between when the contract is formed and when acceptance must arrive. Third, rejection ends the offer instantly under Sub-Article 2, even if the deadline has not yet passed. Examiners love to test this point with tricky fact patterns where the offeree first rejects, then tries to accept. Always say no contract is formed in that situation. Also, do not forget that Article 1690 works together with Articles 1691, 1692, and 1693, so study them as a group, not in isolation. Thank you for watching. Whether you are an LLB student preparing for your contracts exam or simply a curious citizen who wants to understand Ethiopian law better, we are glad you joined us. Please subscribe and stay with us for more lessons on Ethiopian law.